In 2021 in Mississippi at a poultry processing plant, a worker was killed when his sleeve got caught in heavy machinery. OSHA issued, after conducting an inspection, OSHA issued a citation. The company contested the citation, and this case has proceeded since 2021 all the way up to the Fifth Circuit, the U.S. Court of Appeals for the Fifth Circuit. They just recently issued their opinion in this matter, and we're going to discuss both sides' arguments as well as the Fifth Circuit's opinion on a number of the defenses raised by the employer in this, the August 2025 edition of the OSHA 3030 with Manesh Rath. Well, hello, everyone. I'm Manesh Rath, and welcome to the OSHA 3030. I'm an attorney at Keller and Heckman, where for 25 of my 30 years, I've been practicing representing management side in the field of occupational safety and health law. And I'm joined today by my friend and colleague, Ben Idzik, on our OSHA team, also who engages in other areas of law like environmental law, transportation law, employment law. Ben, thank you for joining the OSHA 3030 today.
Thank you for having me. It's great to be here.
It's great to have you here. We have an important case, one that a lot of members of the occupational safety and health law bar have been following for a number of years. Indeed, Ben, we've covered this issue on a previous episode of the OSHA 3030 when it came up as a review commission decision. And here we are again on this case, on the case of Marjack Poultry versus the Secretary of Labor. Because this case, I think it's exceptional just because it's gone all the way up to the U.S. Court of Appeals in one of the U.S. Court of Appeals circuits, this one, the Fifth Circuit. I think it's also exceptional because of some of the defenses that were raised and the issues that the Fifth Circuit had to rule on. Yeah, why don't we talk about what we're going to talk about today?
Yeah, certainly. So like we always do, we'll begin with a brief overview of the facts of the case, what led to the citations, and what was found by OSHA after the inspection that you mentioned.
Yeah, the facts of the case are important in order to understand Marjack's defenses and OSHA's arguments against those defenses.
Right. And then we're going to go overview a quick history of the procedural history of the case, the history of how the ALJ ruled, how the review commission ruled, and ultimately what got the case to the Fifth Circuit.
Yeah, the agency's really had a long journey from conducting an inspection to receiving this opinion from the Fifth Circuit. And then finally, we're going to talk about what the Fifth Circuit's opinion was on some of the defenses raised by Marjack, the employer.
Right. And we will pay specific attention to one of the defenses that was raised, the interest custom defense. And finish it off, as we always do, with a practical section on what employers should do because of this case.
Yeah, I think that is where a lot of folks tune in around the country and around the world. We also sometimes, when we do this live, have a section called Off the Record. And this Off the Record session is strictly for the folks who attend the live session. If you are interested in having that section return and for us to do this live so that we can do questions and answers for the live participants in the live webinar, please shoot us an email either to Ben directly or to me and let us know your thoughts on that section. Happy to bring it back. All right, let's first talk about the background of this case, because I think this is really important in understanding both sides' arguments.
Right. So Marjack's is a company, it's known as a poultry processor. And what they do is they take chickens, they slaughter the chickens, and then they prepare them for distribution to wholesale distributors and major national fast food restaurants.
And poultry has its own challenges. It clings to the material, clings to the machinery. Material can get jammed in the machinery, and all of this has to be constantly observed, monitored, and maintained in real time.
Right, exactly. Just to put in a phrase, I think the food doesn't grow on the shelves of the grocery stores. There's a long way to get there.
That's right.
So Marjack's maintains a facility in Hattiesburg, Mississippi, like Manesh mentioned. And in this facility, it utilizes two main Maestro eviscerators.
The eviscerator is the type of machine. Main Maestro is the brand.
Right, exactly.
Sometimes referred to as the Maestro.
Yep. And the machine, what it does is it takes chickens that have been hung by their legs, and it takes the internal organs out of the chicken carcasses. It does this at a very rapid speed. about 175 birds per hour.
A minute, but the normal rate is something for other processing facilities is something lower, like 125.
Exactly. So around these machines, Marjax assigned employees to work around them. And that's really an important point to keep in mind. Um, Marjax says that the workers who worked around these machines, called floor persons, they were responsible for cleaning and monitoring the machine so that it's running. The machine itself was fully automated, so there wasn't direct worker contact to actually perform the evisceration. These workers would work around the machine, and if jams occurred, the protocol that Marjax initiated was that they would have to stop the machine to clear the jams. And that's something that in this case we will see that it wasn't as clear as Marjax's kind of opening argument on this. But these machines, they also were equipped with two emergency stop buttons. So two means to turn off the machine in an emergency and non-emergency situation. The first was a red safety cord that encircled the machine, that if pulled would stop the machine.
Envision this like a pull cord on a bus where
Exactly.
when you pull it, the machine stops instantly. And because it circles the machine, Marjack argued that it was arguably reachable from anywhere that a worker would be likely to be positioned.
Exactly. And it also featured a stop button on the actual machinery. So the worker could go over and press the button and that would power the machine off.
And that red emergency e-stop was available at one location where operators were likely to find themselves.
Exactly. And the way that this particular facility was designed is that it had two eviscerators, two of these machines, a machine on line one and a machine on line two. And there's a subtle point that the court discusses with the difference between how these two machines were equipped. The machine on line one had metal doors that enclosed the rotating parts of the machine. The machine on line two did not. And we'll see that the court will pay attention to this as this decision unfolds.
Right. In order to achieve such high line speeds, this highly fully automated process put birds on carousels, and the carousel will continue to rotate around to the operating part that eviscerated the carcass. And these carousels were rotating at very high speeds. And sometimes a bird would get slightly dislodged or fully dislodged. Sometimes material that was eviscerated out of the bird would go to the wrong place. It was supposed to go into a pan and then from there drain into a refuse drum. And sometimes it would get stuck along the way. So these carousels are rotating, carrying birds at a very high rate, and the rotating carousels were enclosed, as you say, on line one by metal doors, and line two was exposed without any metal doors. But here's the other important point about that metal door guarding on line one is that they were not interlocked. I think that that's critical. That you would think that another mechanism that could be introduced would be that when the metal doors are opened, that an interlock would cease the rotation movement of the carousels instantly. And in this case, the metal doors were strictly guarding. They had no lockout role to play through an interlock device. So if you opened the doors, you would still be exposed at that moment to fast rotating carousels. So thanks for the opportunity to add that point.
Yeah. So then the incident itself, a floor person, the name were kept anonymous, went by the initials BB.
And the specific job title was
The right floor
floor
person,
person.
right? And like we briefly discussed the last slide, the floor persons were responsible for things like housekeeping, floor washing, ensuring that the equipment was running properly. And on May 31st, 2021, the BB was assigned to work as a floor person around the line two machine, which
This is the one that didn't have the doors.
exactly. Yep. And in that process, somewhere there wasn't actually a witness to the incident. BB's left sleeve appeared to have gotten caught in the rotating parts and entangled, and then he was subsequently pulled in and very brutally and tragically killed.
Yeah,
because
then
of
to
it.
be clear, because it's not on the face of the slide, that this is conjecture, this is speculation based on photographic imagery of BB after the accident, based on his position.
Mhm.
And the nature and location of abrasions on him. But one thing's clear is that he was clearly pulled into the machine and killed. The rest is the conjecture based on the forensic evidence, let's call it, including photographic imagery of his position upon being found, and that it was thereby sort of reconstructed speculatively that his left sleeve may have gotten caught first,
Yeah.
thereby pulling him right into the machine and essentially breaking him, crushing him almost instantly. So, so this was the speculation not only of the compliance, safety, and health officer, but also of coworkers who saw BB after the accident and knowing his activities, his duties, and his position, speculated that he may have been reaching in to maybe to clear a jam
Right.
while the machine was running. So that I think is a really critical points to make that this was the speculation that a lot of people had come to, not only the compliance officer, but also coworkers, including the coworker who did his job for line one,
Right.
his counterparts to line one.
Exactly. And sort of another interesting aspect of the post-incident facts of this case is that a toxicology report was conducted on BB, and it revealed that he did have alcohol and marijuana and methamphetamine in his systems at the time of his death. So that adds a wrinkle to the case that the courts and the review commission ultimately address.
The whole story is tragic, and the presence of alcohol, marijuana, and methamphetamines is particularly aggravates the tragedy of this story because you would think theoretically that this was one preventable element, but there were so many preventable elements to this story and the arguable causations or causative factors that it doesn't necessarily benefit the OSHA 3030 community to focus on just this one. But I do agree it's an incredibly important part of the equation that BB was found with volumes of alcohol, marijuana, methamphetamines in his system at the time of the postmortem.
Yeah. So, like you mentioned, Manish, after the incident, as is required, OSHA immediately conducted an investigation following it, and they did issue two citations, one of which we'll focus on, which is the machine guarding citations. And through this citation, OSHA alleged that the rotating carousel on the Line 2 machine posed a rotating hazard and it was unguarded. They noted that the emergency stop cord was not an effective hazard around the machine. And they noted that clearing jams without stopping the machine was a practice that was fairly routine at Marjax at that particular facility. Um,
Yeah, the testimonial evidence came from coworkers who said that they not only had at some times reached their hand in to clear material, but they did it routinely as a matter of common practice, that they've seen supervisors routinely reach in to the eviscerator zone of danger to remove material, that they've removed material while supervisors were watching,
mhm.
and fourth, that they had been instructed by supervisors that this is how you would remove material from the carousel uh, in order to clear a jam or to clean a part. So those four distinct types of testimonial evidence were presented to the compliance officers during the inspection.
So Marjack's defense is Marjack's, I guess, principal defense was that the Line 2 machine did not present a hazard. It was not aware that it presented a hazard um, to the workers around the machines. And factual reason behind that is they mentioned that the floor persons were not responsible for clearing jams while the machine was in operation. They were only responsible for monitoring the machine, performing housekeeping, upkeep of the general area around it.
Yeah, Marjack's argument was the floor person was only supposed to clean the floor,
Mhm.
thus the title, maybe the outside of the machine, hose things down, use squeegees to clean the outside of the machine, the area around the floor where material has dropped at the wrong location. It's supposed to drop into a pan and then shoot to a refuse bin. And if it falls outside of it, to clean that up or to squeegee it into a drain. And and so the cleaning of the machine or anything inside the machine That is conducted during shift two when the machine is no longer operating. That was Marjack's argument. So therefore, as you say, Ben, they're arguing we didn't have any knowledge that this kind of unjamming while the machine was operating was going on. It wasn't in their job description.
Yep, exactly. And then they also raised an unpreventable employee misconduct defense, which, as a general overview, is a affirmative defense that says that yes, a violation occurred, but the violation occurred because of unexpected and unforeseeable actions of the employee. And usually, for background for the OSHA 3030 community, there are four elements you have to show to make this defense. You have to show that there's a safety rule in place that addresses the hazard, that rule was communicated to employees, that the employer took steps to enforce and discover violations, and the fourth, like I think I jumped ahead a little bit, is that enforcement of the rule does take place. So Marjax made this defense saying that, we had rules in our training materials, in our employee manuals.
Part of it was what we just discussed, that it wasn't even in his job
Yep.
description, and generally that you shouldn't reach into the machine while it's in operation.
Yeah. And I think one of the things that subtly, or if not so subtly, underlined this argument was the fact that BB did have those intoxicants in his system, and that's something that Marjack speculated could have contributed or led to his conduct in reaching in to clear the jam in this case.
So coming in under the influence of alcohol, marijuana, methamphetamines was an element of an unpreventable employee misconduct offense. Let's go ahead and talk about, so OSHA issued citations. You've heard Marjack's arguments. OSHA prevails at the original stage before an administrative law judge. The administrative law judge affirms the citations issued by OSHA. This went to the commission, I believe, if my recollection serves me, at a time where all three positions were not filled, and the commission affirmed the administrative law judge's decision. Then Marjack appealed this to the U.S. Court of Appeals for the Fifth Circuit. So that is the procedural history. Now it goes before the Fifth Circuit. Marjack raises its arguments again. OSHA issues its arguments again. Marjack's arguments that essentially that they had a policy in place, that employees were trained not to use their hands to reach in when the machine is working, and that as well there was an e-stop and there was a pull cord that could have stopped the machinery, and that they had effective methods for keeping the employee safe, and that the employee was not supposed to be near the zone of danger anyways, that distance from the machine qualified as an acceptable method for guarding by distance, and that in fact was quite common as an industry practice. OSHA responds to the Fifth Circuit with its arguments.
Right, and on this industry custom point, what OSHA does is they say that regardless of whether the standard requires a specification, meaning that it has to um, meet a certain standard, or it requires a performance-based standard, the outcome is the same either way. Marjack would have lost because of the issues with the location of the stop cord and of the lack of guarding, the lack of the interlocking door that was provided on the when compared to the line one machine.
Right. And I think that they're probably most persuasive, the agency, when they show the evidence that they presented in the lower hearing before the administrative law judge, showing that workers were doing this routinely, and that supervisors had witnessed it, and that supervisors themselves had engaged in reaching their hand into the machine to clear jams. That evidence, Ben, you'd point out when we were discussing this case, the review by the Fifth Circuit is going to be based on the evidence submitted before the administrative law judge and whether or not there was any error. And the Fifth Circuit said that evidence was credible. I think that is a really important point for employers to keep in mind when they go to the appellate level. It is not a trial de novo. It is not a brand new trial where they get to represent evidence. Not that Marjack was attempting to do so, but that the standard by which the Fifth Circuit is going to review Marjack's arguments was and will always be whether or not the administrative law judge, in its credibility findings, in its review of the evidence, acted in any way that demonstrated a plain error. So the Fifth Circuit said that the administrative law judge uh, reviewed OSHA's evidence and found that there was plenty of credible evidence as to Marjack's knowledge, Marjack's actual practices, notwithstanding its written policy, and that they found that those were sufficient evidence that a violation had occurred, notwithstanding whether or not there was any evidence by Marjack as to what industry practices were. But these industry practices, Marjack was arguing, related to the pull cord being a sufficient device to make the employees safe, and that the distance to the machine was sufficient to keep the employees safe. And so the Fifth Circuit said, well, we're looking at the evidence that was submitted in court, and most importantly, we didn't see that Marjack presented any evidence of what the industry custom or practice was. Specifically, we didn't see evidence that other employers were using distance as a means of guarding the employee, for example.
And I think that, like you mentioned before, the contrast between the line two machine and the line one machine with the presence of those guards, I think was a critical fact.
Yeah, that's right. That's a good point. There's actually two points that you're touching on here. One is that on line one, Marjack's own argument that distancing was an acceptable industry practice is belied by the fact that the other line one, had these doors guarding the machine.
Mhm.
So that accidental caught by hazard of a sleeve would not be possible if the doors were closed and the machine was running. But the other, I think, critical part is when you look at not only that line one, but the machine manufacturer's own instruction manual.
Right.
That the Fifth Circuit said, well, that really is also some evidence of what a custom or practice in the industry might be, because the manufacturer supplies this machine not only to Marjack but to
Mhm.
other processors, and it implied that the distancing was not sufficient. I thought that the instruction manual language was not clear, and I also find it telling. The Fifth Circuit kind of was selective on that point, because I find it telling that nevertheless the manufacturer of the equipment sent it off without
Mhm.
machine guarding,
Right.
without the
Exactly.
doors on it.
Yeah.
So I think that argument could have been made better by Marjack, that well, look, this machine, if the instruction manuals have any probity, then you should also look at the fact that the machine manufacturer sent it off without the guarding.
Yeah.
I think that they should have probably taken the time to put more evidence in as to what was going on at competitive
Mhm.
processor facilities. And they may have found that they were right,
Mhm.
that guarding was, for some reason, not placed, and that there were distancing barriers that were used instead. I don't know.
Yeah.
But we won't know because that evidence was not supplied.
Exactly. They also discussed the notion of the pull cord, and there was a pull cord on both line one and line two. But the problem with the pull cord on line two that the court discusses is that it was too high to provide a ability to stop the machine. I believe it was over 6 feet.
Is it 6 feet? And that's not too high if you're standing straight. And no matter what the height of the worker is, most everybody can reach a 6 foot cord. But if you have your hand in the machine,
Right.
then you're not going to be able to reach the cord, is what the Fifth Circuit opined. And I think that that was reasonable, that the cord was too high if reaching into the machine at the same time.
Mhm. And then the court, came down and interpreted the standard as requiring barriers to be present when feasible, rather than guarding by distance.
This is interpretive. This is a good point. You did say that, but that Marjack was arguing that this is a performance standard, and that provided that there's sufficient guarding, that the employer should have the flexibility to devise the guarding method that they think is most effective. And that Marjack, it argued, did choose guarding by distance instead of guarding by barrier. The Fifth Circuit rejected that, looking to prior decisions, precedential case law, and said that the courts had already opined that the interpretation of the standard was that physical barriers should be used when feasible rather than guarding by distance. And so the Fifth Circuit applied those decisions to say that guarding by distance is a second choice. Now the employer has to argue that it was infeasible, and Marjack didn't supply an infeasibility argument.
Mhm.
It only said that both of them are allowable under a performance standard. Both a physical barrier or distance
Mhm.
would be allowable under performance standard. And so the Fifth Circuit rejected that based on prior precedential case law decisions.
Yeah. And to that point, the court did say they found that, Marjack didn't submit any evidence showing that, no action was consistent with industry custom or practice as an adequate form of guarding.
Right, and that's a little circular. Marjack argued that the distancing was their action and the pull cord. I think the Fifth Circuit was on stronger footing by saying that that was inadequate
Mhm.
guarding and therefore violative of the standard. But it's a fair point that there's no evidence as to when you specifically look at their defense that there was an industry customer practice, there was no evidence submitted supporting that at other comparative facilities, and that would have probably benefited Marjack had they submitted that kind of evidence. All right, Ben, we're running out of time on today's edition, so let's talk about what, in light of this decision, we think employers should do going forward.
Yeah, I think the most practical step is to ensure that machines are properly guarded. And this is sort of an obvious point, but one that's sometimes difficult to quantify in a particular situation. So that's why, if possible, consult safety professionals, utilize their services to have a full and objective perspective on what the industry custom for these particular machines that you're equipped with have and what you should employ at your facility.
Third-party consulting firms, auditing firms, occupational safety and health attorneys, these provide a sort of reality check against what one facility is doing because that group of professionals has a bird's eye view, having seen lots of facilities and so that a facility or facility management that thinks that they've done an adequate job of guarding may get a different perspective that's beneficial to them to hear from a objective third party that there may be other methods that are being employed or should be employed to comply with the standard and protect workers, most importantly, from even that small percentage of incidents that could theoretically happen.
Mm. And similar to that point, whether employing safety professionals, it's also important to cross-check the equipment manuals against existing practices.
Yeah, the agency is going to use the equipment manual, the operator's manual, as evidence of what the agency thinks employers should be doing. And I don't know that that's always appropriate or fair or reasonable, but I do think it's enough to know that courts will credit that kind of evidence. And so you have to know what's in the operator's manual,
Mm.
in the equipment manufacturer's literature about that equipment, and to make sure that you've contemplated everything that the equipment manufacturer has said in those manuals in your practices and in your policies, your training as well to make sure that it's not contravened by the equipment manufacturer.
Mhm. And the third point also is to ensure that workplace safety rules are enforced consistently, and that there's a enforcement record of these actions. And this goes to one of the big aspects of this case with the unpreventable employee misconduct doctrine, where the ALJs, the Review Commission, ultimately the Fifth Circuit didn't buy Marjack's arguments because of the evidence that the rules that Marjack implemented against reaching into the machine to clear jams wasn't at all enforced and was in fact encouraged by supervisors, done by supervisors. So really focus on that because it can come back to cause issues.
Yeah, and these enforcement records, that's a great point, Ben. These enforcement records can come in any form, whether it's an actual disciplinary write-up. It needn't be. It could be just notes taken in walkthroughs with your team, and those are all sufficient records to me that there is a safety rule and that it's being enforced, that you're monitoring for it, that you're catching it, and that you're taking corrective action. That's there's a wide variety of formats in which I'd want to find those records. It needn't be the formal disciplinary write-up.
Mhm. And then fourth, related to the previous point, ensure that supervisors are trained properly on the workplace safety procedures that you have in place at your particular facilities. Again,
And the workers who are going to be exposed
mhm,
to potential hazards.
right.
The material, the content of that safety program needs to be recorded as well as who attended it and whether the employees were tested for comprehension of the training.
Mhm. I think the supervisors they place an extra level of scrutiny because of how they uniquely represent the employer. But for both in supervisors and for employees, the training is paramount.
The other thing that we talked about, Ben, is that it's important for employers to maintain a drug alcohol policy and to refine it, to continue to review and refine it, to keep up with agency interpretations. Unfortunately, OSHA itself has issued an interpretation that really limits an employer's ability to conduct drug and alcohol testing. It has sort of limited the idea that universal or uniform application of testing or uniform application of post-accident testing should be applied by employers. And OSHA's reason is because that might be discriminatory against people who use drugs that are otherwise legal. But that's not OSHA's jurisdictional purview. It's not within their mandates to protect people from discrimination on the basis of legal recreational drugs. They only have one congressional mandate, and that relates to workplace safety. So it's a very unfortunate decision by the agency to decide to abrogate its role in workplace safety in favor of a role that no one assigned it in favor of protecting employees from being discriminated against for lawful recreational drug use. I do hope that the agency revisits that policy and considers revoking that interpretation to give employers greater liberty and license to do the right thing, which is to test for drug use and alcohol use, regardless of whether a particular state has legalized a drug, to make sure that not only is that worker going to be safer, but the workers who are co-located around them and whose safety is affected by the employee who might be under the influence. It's one of the most unfortunate deviations from congressional mandate I've seen from the agency, and I do hope that someday soon, hopefully, they'll revisit that unfortunate interpretive policy that they've taken about drug alcohol testing in the workplace. The statistics are clear that drug or alcohol use during or being under the influence of it while on shift has a deleterious impact upon worker safety. And so, given those clear statistics, those large population statistics, there's just no question as to what the agency needs to do to revise its current stance on that question. That's it for today's OSHA 3030, the August 2025 OSHA 3030. We'll be back again next month. Let me put the date up. It is September 17th, 2025, 1 p.m. Eastern Time. Always on a Wednesday, always at 1 p.m. Eastern. We look forward to seeing you again then. We have sister programs here at Keller and Heckman. We'll have the REACH 3030 and the TSCA 3030. Great programs for those of you whose organizations are responsible for complying with REACH and TSCA. Stay tuned. TSCA is an area of law which is in rapid change, and so it's important that your organization send somebody to those programs. We hope that you join. We hope that you spread the word for both those programs to your colleagues at your organization and at other organizations. And when you get the next invitation for the OSHA 3030, please continue to forward it on to at least 3 new people every episode, so that the OSHA 3030 program and the TSCA and REACH 3030s survive for many years to come through you spreading by word of mouth the good word about the value of those programs. Well, as I said before, I'm Manesh Rath at Keller and Heckman. Thank you, Ben Idzik, for joining me on this program. I'm thankful to everyone at Keller and Heckman, our staff who've helped support producing this episode. And I'm thankful to all of you, members of the OSHA 3030 community, for continuing to be loyal supporters of the program for so many years. And we look forward to seeing you next month. And until then, stay safe.